or media outlet by suing them for defamation.
The deadline was set for noon, a clear agreement etched in legal stone, but at 7:11 a.m. the trap was sprung. The New York Times didn't just break a promise, they launched a calculated strike that changed the industry forever. Justin Baldoni's legal team watched in horror as a devastating narrative went live hours before they could even finish their response. This wasn't just a reporting error, it was a scorched earth campaign designed to bury a reputation before the defense could even draw breath. The battle lines were drawn in that single early morning hour, and now the hunters have officially become the hunted in a defamation war that is shaking the foundations of media power.
As villains and making them scapegoats for Lively's well-publicized.
The fallout was immediate, but the counter-strike from Baldoni's lawyers was even more explosive. They aren't just filing a complaint, they are accusing a pillar of global journalism of acting as a private PR arm for Blake Lively. The lawsuit claims the New York Times plotted for months behind the scenes, coordinating with Lively's team to craft a hit piece that would frame Baldoni as the ultimate Hollywood villain. This goes far beyond a disagreement over creative differences on set. We are talking about allegations of calculated manipulation, where a media giant allegedly traded its objectivity for a sensationalized story that could shatter lives.
A retaliatory campaign to tarnish Lively, after she alleged that Baldoni and Heath engaged in misconduct.
At the heart of this legal firestorm is the powerhouse attorney Brian Fredman, who is pulling no punches in his assessment of the situation. Fredman argues that the Times didn't just report the news, they actively joined Lively's side, vouching for her claims as if they were absolute verified truths. By presenting unproven accusations as settled facts, the newspaper supposedly crossed a line that no journalist should ever touch. The defense team is calling it a blatant abandonment of neutrality, claiming the paper became an advocate rather than an observer. This transition from reporter to participant is the cornerstone of a lawsuit that could redefine the limits of the press.
Echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfair parties and falsely accused them of having.
One of the most damning aspects of the case involves what the lawyers call promissory fraud. Baldoni's side alleges they were explicitly promised enough time to provide their side of the story, with a hard deadline of December 21st. Instead, the Times allegedly hit the publish button while the defense was still scrambling to gather evidence. This wasn't just a minor scheduling mishap, it was a strategic move to control the narrative. By cutting off the rebuttal, the article ensured that the public's first impression was one of guilt and misconduct. It was a move designed to win the court of public opinion before the actual court could ever hear the truth.
Based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times.
The legal strategy here is brilliant and aggressive, focusing on stripping away the New York Times' most powerful defense, the fair report privilege. Usually, media outlets are protected when they report on public legal proceedings, but Fredman argues that the Times forfeited this shield. He claims they didn't just report on the allegations, they effectively vouched for them by stating their own internal investigation had verified Lively's claims. This distinction is vital. If the court agrees that the Times presented these accusations as their own verified findings, the paper could be held liable for every single word of the narrative they helped construct.
It just wasn't fair. And we're going to get into the part where Brian Friedman argues, you gave us a couple hours to respond, we scrambled, and you still published.
There is a massive tug of war happening over where this case will actually be decided, and the stakes couldn't be higher. Baldoni's team is fighting tooth and nail to keep the case under California law, while the Times is desperate to move it to New York. Why does this matter? California is famously more protective of individuals in defamation cases, making it much easier to recover damages for emotional distress. In New York, the legal framework is significantly more favorable to media corporations. By keeping the battle in California, Baldoni's team is ensuring they have the strongest possible leverage to hold the publication accountable for the personal toll this has taken.
Salacious article well before TUI contacted the Wayfair parties the night before publication for quote-unquote fact-checking. After the New York Times months of plotting with the Lively parties, the Wayfair parties got.
The allegations of misconduct at Wayfair Studios served as the original spark, but the lawyers claim the New York Times turned that spark into a forest fire. They argue the paper presented a one-sided portrayal that ignored thousands of pages of documents that could have cleared Baldoni's name. According to the defense, the Times had access to communications and text messages that directly contradicted the narrative being pushed by the lively parties. Instead of incorporating this evidence for a balanced view, the publication allegedly chose to omit it entirely. This selective reporting is being framed as evidence of actual malice, the highest legal bar in defamation law.
Complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfair parties to specify the acts taken by the New York Times in connection with its.
Actual malice is a term that keeps newspaper lawyers up at night, and Fredman is aiming directly for it. To prove this, Baldoni's team must show that the Times published false information while knowing it was wrong, or acting with a reckless disregard for the truth. The defense argues that by ignoring exculpatory evidence and rushing to publish before a deadline, the paper demonstrated exactly that kind of recklessness. They claim the intent wasn't to inform the public, but to solidify a predetermined agenda that cast Baldoni as the scapegoat for Lively's public relations struggles. It's a bold claim that puts the integrity of the Times on trial.
Will determine the truth based on the evidence, but the Wayfair parties' allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfair parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law.
The narrative being pushed by the defense suggests a level of coordination that borders on a conspiracy. They allege that the New York Times spent months plotting with Lively, her husband Ryan Reynolds, and their PR teams to orchestrate this hit piece. Commentators like Lady C have even weighed in, suggesting that the situation looks less like journalism and more like a high-stakes PR stunt designed to protect a major star's brand. While these claims remain speculative, the timeline of events and the early publication of the accompanying video provide a compelling framework for the argument that the outcome was decided long before anyone asked for a comment.
Insists it is entitled to New York law no matter where their harm was felt. But California law remedies harms suffered in California.
Let's talk about that video, because it's a smoking gun in the eyes of Baldoni's legal team. It wasn't just a written article that hit the web early. It was a fully produced video segment that allegedly carried a timestamp of 7:11 a.m. This timing suggests that the final product was finished and ready to go well before the defense's response deadline had passed. Fredman argues this proves the outreach for a comment was nothing more than a formality. The Times had already made up its mind, and no amount of evidence from the Baldoni side was ever going to change the story. It was a foregone conclusion, wrapped in the guise of fact-checking.
Or New York law, the Wayfair parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts, and thus the New York Times is shielded by the fair report.
The damage to Justin Baldoni's reputation has been immense, and his lawyers are making sure the court knows the full extent of it. He was painted as the mastermind behind a sinister smear campaign, a label that can be career-ending in the modern industry. The defense maintains that this characterization was a fabrication designed to distract from the actual events at Wayfair Studios. By casting Baldoni as the villain, the Times provided a convenient target for public outrage, effectively shielding others from scrutiny. This use of a public figure as a sacrificial lamb is at the heart of the claim for significant financial and reputational damages.
Statements affect my client specifically in California. And you know, this modern world we live in with the internet really makes it that you're damaged no matter where the defamation.
The New York Times is not taking this lying down, filing motions to dismiss and arguing that they were simply doing their jobs as reporters. Their legal team contends that they were reporting on matters of public concern and that the location of the publication should dictate the law applied. They argue that as a New York-based entity, they should be governed by New York standards. However, Baldoni's team points out that the harm was felt in California, where the parties live and work. This jurisdictional battle is the first major hurdle, and if Baldoni wins it, the path to a massive payout becomes significantly clearer and more dangerous for the Times.
Has long presumed itself beyond accountability. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's.
The text messages mentioned in the lawsuit are particularly interesting, as they supposedly provide a different context to the working relationship between the parties. Fredman alleges that the Times selectively used bits and pieces of these messages to create a misleading impression of misconduct. In the legal world, context is everything, and the defense claims that when the full picture is revealed, the accusations against Baldoni crumble. By stripping away the nuance, the newspaper allegedly created a false light that made professional disagreements look like sinister actions. This manipulation of evidence is a central pillar of the claim of journalistic malpractice.
For the veracity of its false narrative, the fair report privilege the New York Times seeks to hide behind does not protect it from
Crucially,
The concept of the fair report privilege is supposed to be a shield, not a sword, but the defense argues the Times used it to slash through Baldoni's career. By claiming their internal investigation backed up Lively's version of events, they essentially told the public that there was no other side to the story. This is a crucial point for the jury to consider. Did the Times act as a neutral platform for claims, or did they become the judge and jury themselves? When a media giant of that scale lends its credibility to one side of a dispute, it can be impossible for the other side to ever recover their standing in society.
colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfair.
The Wayfair parties are standing firm, insisting that they were the ones who suffered through a retaliatory campaign. They argue that the narrative was flipped on its head to make the victims look like the aggressors. This legal battle is as much about the truth of what happened on set as it is about how the media handles sensitive allegations. If the court finds that the Times was negligent or malicious, it could send shockwaves through newsrooms across the country. It would serve as a warning that being a massive media institution does not grant immunity from the consequences of biased and harmful reporting practices.
Claims for false light, promissory fraud, and breach of implied.
The strategic choice to seek emotional distress damages highlights the personal toll this has taken on Baldoni and his associates. Beyond the professional loss of work, the psychological impact of being labeled a villain by one of the world's most respected newspapers is staggering. Under California law, these damages are much easier to quantify and recover, which is why the battle over jurisdiction is so fierce. This isn't just about a paycheck, it's about acknowledging the human cost of a narrative that was allegedly built on half-truths and broken promises. The defense is determined to see that cost paid in full.
That the New York Times conspired with Lively, Reynolds, Sloan, and Vision PR to advance a false and defamatory narrative.
One major question remains. Why would a pillar of journalism take such a massive risk? The defense suggests it was the allure of a sensational story involving high-profile celebrities. In the race for clicks and engagement, the pressure to deliver a definitive, scandalous narrative can sometimes outweigh the commitment to rigorous fact-checking. Fredman's team argues that the Times fell into this trap, prioritizing the lively narrative because it was more compelling than the complicated reality. They claim the integrity of the journalistic process was sacrificed at the altar of a viral headline, leaving a path of destruction in its wake.
In sexual misconduct towards Lively, and 2, allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's.
The motion to dismiss filed by the Times is a standard legal move, but the response from Baldoni's team was anything but standard. They met the challenge with a mountain of counter-arguments that painted the Times as a co-conspirator rather than a reporter. They claimed the newspaper cannot hide behind its status when it actively participated in the harm. By framing the Times as a collaborator with Lively's team, the defense is attempting to bypass many of the traditional protections afforded to the press. It's a high-stakes gamble that could either lead to a massive victory or a swift end to the lawsuit.
Problems that does exist when it comes to news organizations is you want them to be protected so they can't just have malicious people come after them if they don't like.
The timeline of the alleged coordination between the Times and Lively's team is a central focus of the discovery process. If Baldoni's lawyers can prove that the two groups were working in tandem for months, it would devastate the paper's claim of neutrality. They are looking for communications that show a shared agenda to target Baldoni and the Wayfair parties. This kind of evidence would be the smoking gun needed to secure a win. The defense is banking on the idea that the paper's internal communications will reveal a shocking lack of objectivity and a bias that influenced every stage of the reporting.
At least try to tell both sides of the story, or do they not?
What makes this case so captivating is the clash between two different types of power, celebrity influence and media authority. On one side, you have Blake Lively, a massive star with a powerful PR machine. On the other, the New York Times, an institution that shapes public perception. Baldoni finds himself caught in the middle, fighting a battle on two fronts. His legal team is trying to prove that these two powers joined forces to crush him. It's a narrative of David versus two Goliaths, and the outcome will likely hinge on whether the court views the reporting as a public service or a private hit job.
For them to double down on their beliefs that they did the right thing versus admit defeat.
As the legal wrangling continues, the public trust in media is once again under the microscope. This case highlights the dangers of narrative shaping in an age where information travels at the speed of light. If a newspaper can be sued for how it frames a story, it could lead to a more cautious and balanced approach in the future. However, it also raises concerns about the ability of the press to report on powerful figures without the fear of crippling lawsuits. Baldoni's team argues this isn't about silencing the press, but about ensuring that when they speak, they do so with a commitment to the whole truth.
In both the article and video, the New York Times presented as unquestioned fact the false and defamatory claim that the Wayfair parties orchestrated a smear campaign, citing to thousands of pages of documents it had reviewed, and claims that the text messages show that the Wayfair parties had engaged in the wrongdoing.
The defense team's insistence on accountability is a recurring theme in every filing. They argue that no organization, no matter how prestigious, is beyond the reach of the law when they cause intentional harm. Brian Fredman's aggressive approach has put the New York Times on the defensive, forcing them to justify their editorial choices in a way few publications ever have to. The stakes are impossibly high for everyone involved, and as the evidence continues to mount, the world is watching to see if a media giant will finally be held responsible for the lives and careers left in the wake of its reporting. Ultimately, this legal saga is about more than just a single article or a celebrity feud. It's about the very nature of truth in the modern world. When the dust finally settles, we will have a much clearer picture of where journalism ends and advocacy begins. Justin Baldoni and his legal team are determined to prove that the New York Times chose a side, and in doing so, they lost the right to call themselves neutral reporters. Whether they can convince a jury remains to be seen, but one thing is certain: the era of media giants operating without consequences is facing its most significant challenge yet in a California courtroom.